Hello and welcome back to Diddy on Trial from the BBC World Service YouTube channel with me, Anoushka Mutanda-Dougherty. Make sure you subscribe so you never miss a thing. How many times have we said during the prep and the build up to this trial that it all felt a little speedy? How many times has our resident criminal defence attorney Shaun Kent told us that he thinks the prosecution and the defence are playing a game of adjournment chicken? He says that neither side are ready and they're waiting to see who will blink first. Well, someone blinked. It was the defense, and they blinked big. They turned up in court and they asked the judge, that's Judge Arun Subramanian, for a 2-month delay. And he said, not today. If you're not ready, get ready. Pratiksha Gildial is a senior producer for the BBC in New York, and she was in court with Diddy. Hi, Pratiksha.
Hi, Anoushka. How are you?
I'm good, thank you. I'm interested to hear what the main requests were in court. What did it all kick off with?
Right. So, Anoushka, we saw Diddy in court not once, but twice, on Monday and on Friday. On Monday, if you remember, he was arraigned on additional superseding charges, which means he was produced in court. He pleaded not guilty to additional charges, which have been brought by federal prosecutors, which include trafficking as well as engaging in prostitution. Now, these are more recent charges from recent years and involve a new alleged victim, apparently. On Monday is the first time we had heard that they may ask for a delay, for an adjournment, and on Friday and on a couple of days after that, they did file a letter asking for a 2-month delay.
So when they asked the judge, was it the first thing that they said, we want this 2-month adjournment and we're letting you know now? How did it come about?
It was basically the judge saying, what are the issues that we need to look at? What are the issues we need to iron out? And that's when the defense said that, we need more time. But then the judge said that, it was a very broad request and they do need to make it more specific and narrow it down. When he denied the adjournment motion on Friday, he did say that it was too close to the trial.
And when the judge denied the adjournment, what was the reaction from Diddy's side of the room?
Once the judge has said the motion is denied, they just had to accept that. But then the judge was very clear. He was like, this is not a time for a fishing expedition. And Diddy does have 4 attorneys. So between them, they should be able to work it out and be prepared in time for a jury selection, which starts on May 5th, and opening statements, which start on May the 12th.
And how was Diddy in the room?
He appeared wearing like sort of light tan prison attire, and he was wearing slip-on shoes. He looked fairly relaxed, if a bit solemn. He's grayed substantially past few months, like silver hair. His beard appeared pretty trimmed, like he, maintained it well. He seems to have lost weight. And on Friday, his mother and one of his sons were there at the hearing, and there were times when he was, we were seated behind him and all the lawyers, and there were times when he turned back and he was probably either looking at his mother or his supporters, and there were times he was nodding to what the judge was saying. One thing that struck me was also that when he entered the courtroom, he hugged each and every one of his lawyers before he sat down, and he engaged with them. He was talking to them, nodding along.
I think this is really interesting because from the beginning, he's pushed for this speedy trial. So what was his exact reaction when the 2-month adjournment was denied?
From what I could see sitting some rows behind him, he just seemed to listen to the judge denying the motion calmly. I think it would have been a big support for him to see his mother, to see his son. There were other supporters. There was one supporter wearing a free puff sweatshirt. He turned around. At one point, he seemed to say, "I love you" to his mother, is my understanding.
You mentioned there was a supporter in the room with a free puff Free Puffy t-shirt on, Puff being like a previous name that he had as a rapper. How many people in the courtroom are his supporters? Because it is open to the public.
There were members of the public, there were a few supporters, there were just a few people who are interested in following the case in general. Of course, a lot of journalists that were there. There were lawyers, a whole host of them, including from Warner Brothers, who have been asked to turn in outtakes from the Diddy documentary. So a fairly mixed but pretty packed courtroom for a pre-trial hearing. It's not the start of the trial, and it struck me as pretty packed. There's also, it's a federal court. It has high security. Only paper and pen allowed inside, no electronics to journalists like us.
Pratiksha, thank you so much for joining us. That was the BBC's senior producer in New York, Pratiksha Galdial, who was in court with Diddy last week. Now it's time for Elsewhere in the Diddyverse. Regular listeners to Diddy on Trial will know the name Tony Buzbee by now, but in case you need a reminder, he is the Texan trial lawyer who claims to have, or he told the BBC that he had 150 cases against Sean Diddy Combs. He's now representing an anonymous woman known as Jane Doe, who has accused former NFL star and Hall of Fame inductee Shannon Sharpe of rape, sexual assault, and sexual battery. Shannon Sharpe denies all the allegations. Now, Diddy is not mentioned in this lawsuit, but you might be thinking, how on earth do I know the name Shannon Sharpe? I'm not a fan of the NFL. Well, that's because if we cast our minds back to the beginning of 2024, Shannon Sharpe had Cat Williams, the comedian, on his podcast, Club Shay Shay, and Cat was very forthcoming about his views on Diddy, saying, "When Diddy wants to party, you have got to tell him no." Now, Shannon is being sued by the same man that is going after Diddy. But Shannon has not been quiet. He released a statement from his lawyer on his Instagram that said the lawsuit was a blatant criminal attempt to shake down Mr. Sharpe for millions. The statement was accompanied by texts of a graphic sexual nature that Shannon claims that Jane Doe sent to him. One of the alleged texts says, "I want you to put a dog collar on me and choke me." Shannon also named the Jane Doe. Now, I went to Tony Buzbee with all of this, and here is what he had to say. Just a warning though, this does contain language you might find offensive. Number one, those texts were sent before the alleged rape. Number two, Shannon Sharpe has been in mediation since February with the Jane Doe. A settlement amount was reached, which Buzbee alleges to be $10 million, and the Jane Doe decided to turn that down. Number three, Buzbee also sent along an audio recording of an alleged interaction between the Jane Doe and Mr. Sharpe, where it appears Shannon threatens to, quote, choke the shit out of the Jane Doe. She says she doesn't want to be choked, and he later responds, quote, "Yes, you do. I don't think you have a choice in the matter." Here is Shannon's response to that.
To my family, friends, supporters, and colleagues, I want to speak to you directly and from the heart. This is a shakedown. I'm going to be open, transparent, and defend myself because this isn't right. This is all being orchestrated by Tony Buzbee, who has targeted Jay-Z. Tony Buzbee targets black men, and I believe he's going to release a 30-second clip of a sex tape that tries to make me look guilty and play into every stereotype you could possibly imagine. That video should actually be 10 minutes or so.
Now I'm joined by our resident criminal defence attorney, Shaun Kent. Hi, Shaun.
How are you doing?
Shaun, firstly, this civil lawsuit that's filed by Tony Buzbee against Shannon Sharpe. Shannon has responded in a lengthy statement on Instagram where he firstly names the Jane Doe and then includes alleged texts sent by the Jane Doe to him. Is that legal?
Technically, a lawsuit is just the filing of a lawsuit. It's a complaint. It's one party saying something that has happened. The other party gets a chance to respond, which is called an answer. That answer is filed out and filled in court. Now, in his answer to the court, he cannot respond to her name. But to John Q. Public, he can do whatever he wants until a court specifically tells him no. And no court has ordered him not to, so it would be the equivalent of if I knew her name or her cousin knew her name or anybody who knew her name and went on C-SPAN and just said, "I want to talk about her." So there's nothing to stop it. Most people don't do it, but there's no court order stopping it right now. It's rare and it's wild, and I thought it was interesting.
Can it not annoy the judge, put you in bad standing with the judge if you do something like that?
Absolutely, and that's the thing that people forget. It may not be illegal, but it is frowned upon. The judge will call them in and say, "You know what you're doing. You're trying to intimidate. You're trying to harass. This is not proper." And Shannon's response is going to be what we've been talking about all the time. She sought to bring the lawsuit. She should not be allowed to have anonymity. And so they're going to go back and forth on that. But yeah, it's going to annoy the court 100%.
Now, Tony Buzbee clearly has a reputation for taking on high-profile individuals, and this is the latest one. We told you about Andrew Tate before, and of course P. Diddy, and we'll keep you up to date with anyone else who gets wrapped in the web of the Diddyverse. But now, Shaun, I need to talk to you because you actually have the inside story on what's going on Diddy's defense team, because his newest lawyer, Brian Steele, is a dear friend and colleague of yours. Who is he? How do you know him?
Brian Steele, we've known each other probably going on about a decade. We met each other in a federal case that we had down here in South Carolina. He was brought along to help a co-defendant. So we didn't represent the same people, we represent co-defendants. So we spent about a month together in steamy South Carolina, Columbia, South Carolina. I am wearing a couple of organizations, some high-profile organizations throughout the country together, American Board of Criminal Lawyers to be one. I consider Brian the best of the best. He is a quality trial lawyer. He's a quality lawyer. He is a great person. He is known for, the best way to describe it, he's known for being incredibly polished. He is well thought out. He is meticulous. He's just a hard worker. He is a lawyer's lawyer. He is a really, really good lawyer.
And what do you think his first thing would be when he came on board, part of the team? What would he say first?
But if I know Brian the way that I know him and the amount, and let's not forget, this is a terabyte of information, which basically means you can stretch each paper around the world. That's how much information there is. Knowing Brian, he said this trial is starting in May 5th. I'd love to be a part of the team. One, what do y'all envision me doing? And two, most importantly, do I have enough time to get what I need to get done? I bet you they told him that we'll be asking for a continuance. My assumption is that they said, we believe we will be getting the continuance, and then wah, 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 it didn't happen, and so everybody's regrouping now. I understand the logic now, but at the time, the thought process is you try to give the benefit of a doubt to a defendant, because if he is convicted and you make an error of law or an error of some sort, then there's always a chance that it could be an appeal, and we could be doing this whole thing all over again. Like if a higher court says you should have given him more time, then I always find that judges are just like, look, we've never asked for one, let's go. Well, the protection this judge had is, and I said this earlier, those idiots asked for a speedy trial. And when you ask for a speedy trial, a judge can say, you wanted it, you got it, let's go. And number two, you waited way too long or too close to the trial to ask for a continuance. So I think the judge's logic was perfect.
Aside from the adjournment, there were some other things that really caught my eye. Firstly, let's do it now. 404B evidence, Rule 413. Let's get it over and done with. Guys, we've told you about this many times. Previous bad acts that Diddy may or may not have committed being brought into the trial as evidence of the kind of character he is. Am I right there, Shaun?
That you 100% have it. His prior bad acts that show that he is conformity with his current accusations.
So it says Combs' motion to exclude 413 and 404B evidence is denied as to victim 5 and otherwise granted. What does that even mean?
That's the part that's crazy. Victim 5 has got some, victim 5 clearly has got some smoke against old Diddy. And so you have to read in between the lines. It's got to be, it's the prior bad acts of Diddy against victim number 5. So it's something that he has done in his history or his past or something relating specifically to victim number 5, but it's something that Diddy has done. So we don't know what they are, but the court clearly knows what they are. And the court in reading this motion says, yeah, that's relevant. That's coming in. So for a judge to deny in part and grant in part, tell me the part that he granted is massive. I don't know who victim number 5 is. I don't know what the testimony is, but there's something about the past between her, him, them, and Diddy that's going to be a bombshell.
So all the headlines about the nightclub shooting, all of that saying that's all going to be brought up, we kind of know that it isn't now, unless that pertains to victim number 5.
None of it's coming in. And when we talk about prior bad acts and stuff of that nature, you know, and I made this comment to you guys before, a lot of judges believe this. If your case needs prior bad acts to make your case, then you don't have a case. Your case should stand on its own, on its face. You shouldn't have unrelated stuff to prove somebody's innocence or guilt, because just because somebody was a bad person in 1992 doesn't mean you're a bad person today. And that's what they were trying to do. And now they're saying, no, I don't care how bad he was in the early 90s. Tell me about what he did in 2000 blank to 2020.
And that wasn't the only ruling we have, because we have some reference to victim 1. Now, we've said before on the pod multiple times that victim one's allegations closely align with the allegations of Cassie Ventura, the longtime romantic partner of Diddy. And it says victim one's motion to quash is denied as to prior drafts of the memoir that was provided to the government, and otherwise granted the prior drafts should be produced by April 25th, 2025. So the judge has said you need to produce the previous drafts of the memoir and then give them to the defense.
And if you go through all of these motions we're going to talk about, they all come to a central rule called the rule of completeness. And here's what the rule of completeness says. And it ain't complicated, it's common sense. If you and I are in the middle of a massive text thread, massive, that is 7 months long, and one portion of the text thread, I catch you talking about your boss, but if it's taken out of context, it doesn't make sense. The rule of completeness says, no. If you bring in one portion, the other side can bring in everything so they can bring a full presentation as to what actually happened. And so if you look at all these motions, what the judge said was outtakes, prior drafts, that's information that's necessary, because why were there changes? Who made these changes? What was this information? You need to give it all because the defense has a right to make a full presentation of the full view. I don't know what the prior drafts are, but maybe some publisher, some editor came in and said something to the effect of, you need to take this out because it doesn't sound scandalous enough, or it sounds too scandalous. So Diddy's team wants the rule of completeness. We don't want you to tell this one small memoir with a part. We want it all in. And so the rule of completeness, I think, is what controls all of these other motions being granted.
And you mentioned there briefly another motion that was granted whereby Warner Brothers were asked to produce the outtakes from a documentary that they made called The Downfall of Diddy. It's for person A and person B. One is a previous chef for P. Diddy and the other is a previous romantic partner. So the judge has said you need to produce those outtakes for the defense to see.
And remember, they haven't seen it yet, so they don't know. And it's one of those you don't know what you don't know. And I've had cases where I've asked for the outtakes, and what'll end up happening, you'd be shocked. You'll see sometimes somebody on camera is crying, emotional, they cut, and then they're laughing and giggling with the crew, and you want to be able to show that for cross-examination. We're doing a podcast now. We all know when the camera's off, people say and do completely different things than when the camera's on. And so that's what his team is trying to do, is look for anything that's different than what is presented to the jury, because if they're just presented what the television shows and what you see when you tune in and not when the cameras are off, you're not getting a full presentation. And anything that can help Diddy cross-examine these folks and say, these guys are lying, they're in it for the money, they're just emotional when the cameras are on, these are the jokes that he was saying. This is a camera crew telling him how to act. If you have to do this scene over and over and over again, let's do that again. We didn't get the emotions out. All that helps his cross-examination, I believe. And I think that's why they want it.
Well, so a few of these are kind of in his favor, so he's definitely had some little wins.
Now, let's not forget, it's not like this is a motion to say, I want to be allowed to use it. This is a motion that says, I want to be able to see it. And he might see it and might not have nothing there, but I think he's dotting his I's and crossing his T's. But here's the problem. I think they made these motions in anticipation of getting the continuance. So be careful what you ask for. You're more in this realm than I am. Outtakes can be a lot.
It's a weird filing that as a journalist, because when you are working with people who are giving you witness testimony, who have alleged that these terrible things have happened to them, and they are in a fragile and vulnerable state, you're trying to create a space or hold a space for them where they can recount what happened, where they feel safe, where they feel comfortable. And then to know that that could then potentially be used as evidence in a trial, it damages the trust in that process a bit.
You're not wrong, and it is. But, from me looking at the other side, the way that I would say it is, Diddy's on trial for his life, whether we like him or don't like him, but he is fighting for his life. And in fighting for his life, he wants every avenue possible. These accusations are coming. But from a journalist standpoint, I'd be like, wait a minute. These outtakes, that damages the process, that we can't get people to be genuine because they're worried about what's going to happen in the cross-examination. And as a journalist, I'm sure you understand, getting somebody comfortable off camera is one of the hardest things to do. And we have to do certain things to get them off camera, and we shouldn't have that used against them when they're on the stand. It goes both ways.
And then we had this last ruling, which I think a lot of people on social media were anticipating. Victim one has said they will appear on the stand, take the stand under their own name, but victim 2, 3, and 4, the judge said, yes, you can appear using pseudonyms. No mention of victim 5 there at all, but I'm assuming there's already a pretty strong precedent for what the judge ruled on that.
Victim 5 to me is the most interesting thing. We just randomly throw in victim 5. Let's not mention her again, her or him or whoever it is.
Surely the logistical considerations for anonymity of 2, 3, and 4 are going to be massive because it's a public trial. There's going to be so much press there. You can see people walking in and out. I mean, how do they appear in court under pseudonyms in an anonymous way?
I'm going to give them protection, and it is like their name will not be used. Their name will not be said in court. And so the court will say you can't report their name, but their name's not reported in court. But as I mentioned, let's say somebody in the courtroom knows who they are. How do you stop that person from just leaving the courtroom and say, you know, that was Tina from Jersey?
And then also a lot of the evidence, which we know or we've been told are video recordings, I imagine it's not outside the realms of the possibility for their names to be mentioned in those recordings or maybe their faces to be in it. Do they need to be blurred and bleeped out? How does that work?
It's called a redaction. It's up to the government and for the defense to go through a redaction method and redact it to the point that the jury will not know the name. Because that's all that matters is the jury knowing the name. The government will redact if there is a name somewhere mentioned, or if somebody says somebody's name in one of those butt naked baby oil freak off parties and they say, hey, Tina from Jersey, bring the Jersey Mike subs. If somebody says her name, then they have to redact that out.
Well, these guys are most likely working day and night.
Yeah, I am in shock. I'm not in shock that they asked for the continuance. I'm very shocked they didn't get it because this is so much information. It's just so, and you just highlighted one of the small things people don't think, little things like the redaction. They have to go through all of these videos and make sure there's not one mistake. And don't forget, if one mistake is made, something small, that can cause a new trial.
Before you go, Shaun, though, we do have some questions that were sent in. I think we've answered, or we've definitely touched on the first one before, but it says, I'm going deep down the rabbit hole. The subjects appeared in the press both in 2024 and much more recently. So here we go. Donald Trump. What is a presidential pardon? In my head, I have the president waving his hand like an emperor and saying, now he is free. No questions asked. Is this the case, or are there restrictions on what can be done? Shaun, I think you've touched on this before, but can you just give us a refresher?
That's almost, it sounds crazy, but that's pretty darn accurate. The president has basically pardon powers over federal crimes, not over state crimes. And, you know, we have individual states. But if something is a federal crime, the president can, with the stroke of a pen, and you may call it the magic wand, he can sign a pardon after somebody is convicted. That is in our United States Constitution, it is allowed. So if there is a conviction, and if Donald Trump wanted to pardon Diddy and just say, you are pardoned from this, you are free, he could. Will he? No.
But it has to be after a conviction. It can't be before. What about a hung jury or a mistrial?
If there is a hung jury and it is through no fault of the United States of America, the case could be retried and would be retried. And that would be if one juror, and it only takes one, who cannot vote and cannot make a decision of guilt.
Shaun, thank you so much for coming on and breaking it down for us today. We really appreciate it.
Thank you for having me. Much appreciated.
That was criminal defense attorney Shaun Kent from South Carolina. And finally, we have this message that came through on WhatsApp. Reminder, the number is +44 330 123 5551. It says, I have a question about the Diddy trial. When the court sessions open, will you be posting live audio throughout the day? So the plan is when the court sits, so we've got opening statements on the 12th of May, we'll be bringing you regular updates as soon as court finishes. I'll be hearing from BBC correspondents and our regular experts for all the best analysis. That's it for this episode of Diddy on Trial from the BBC World Service YouTube channel with me, Anoushka Mutanda-Dougherty.